start. On 2/3/2020, the respondent issued a legal notice calling upon the appellant to release the balance payment of the claim amount arising out of the first fire incident. Stop. The respondent, in the said notice, alleged, inter alia, that he had signed the consent letter and the advance discharge voucher under the apprehension that if he would not have signed the said documents, then the claim in relation to the second fire incident, which was pending on the date of the signing of the discharge voucher, would have been detrimentally affected. Stop para. Thus, the discharge voucher could be said to have been signed under coercion, undue influence, and without free will and volition of the respondent. Stop. The respondent further stated that it had sent the protest letter dated 25/10/2019 immediately after receiving the final installment in relation to the claim arising out of the second fire incident. Stop. The respondent further stated that in the event of the appellant's denial or failure to pay the balance amount within a period of 15 days, the legal notice should be treated as notice invoking arbitration. Stop para. The appellant replied to the aforesaid legal notice on 16/3/2020, refuting the allegations made by the respondent, alleging them to be malified and an afterthought. Stop. The appellant stated that the discharge voucher signed by the respondent was unqualified and on his own free will and volition. Stop. It was further stated by the appellant that the amount being claimed by the respondent was not due in the first place, thereby making the dispute not one of quantum but one of liability, and therefore the arbitration agreement would not be attracted to the dispute raised. Stop para. The appellant, on the other hand, contested the arbitration petition filed by the respondent on the ground that the claim raised by the respondent herein was stale, and having once signed the consent letter dated 24/12/2018, it was not open for it to turn around and raise a dispute. Stop. The appellant also contended that it was open for the court to look into the question of arbitrability at the stage of deciding the Section 11 petition. Stop. Therefore, the above aspects indeed travels to the adjudicatory realm, which is the function to be discharged by the arbitrator. Stop. When the claim is disputed, it is the arbitrator who may competently decide the claim. Stop. Arbitrability of the dispute is also to be decided by the arbitrator. Stop. No order as to costs.